The police say the court always rules in favor of the criminals, and of course criminals say that the court always rules in favor of the police, and the citizens say the court always rules against them at all times, and everybody's against the court and against the court. I just want you gentlemen on the high court to know that I'm not against you. I don't know whether you're right or wrong. I don't preach abortion. And I'm not telling people that abortion's right or wrong or good or bad. I'm not telling people that drunk driving is right or wrong or good or bad. For the purposes of the courtroom drama, we are only interested in the law, not morals or religion. It just happens that our law, our common law, has its roots at Mount Sinai. Now, whether you agree with that or not, it's up to you. But I think as you go through, you're going to find that the common law and substance cannot be divorced from one another. And the substance of our common law was divorced in 1933 with H.J.R. 192. And when that happened, all of a sudden, our common law has now degenerated into the old Roman civil law, or the law merchant, from the Hanseatic League. And they got it from Rome. And Rome probably got it from Babylon, and Babylon probably got it from Egypt, and they probably got it from Nimrod and Semiramis, and they probably got it from somebody who got it on the other side of the flood, who traced it right on back, and you probably got it to Cain. I don't know that, but I'm just saying that, you know, it drifts down to us through the ages. And once in a while, a society will come out of the rubble of slavery, and they'll establish a free society, and they'll establish some law and civil rights and constitutional rights, and then it's submerged in tyranny. I think you'll find that mankind has lived in tyranny a whole lot longer than he's ever lived in freedom. So our high court, then, is charged with the responsibility of maintaining individual liberty through our constitutional protection. Now, they're also a court of original jurisdiction in some limited matters, but it's basically an appellate court, and you take your appeals to them to have the lower courts reversed based upon these major federal questions. Now, the Terry case is called the Terry Frisk. I want to give you a little background on this as we get into it. Now, there's a policeman in this case, and this particular policeman, whose name is McFadden, who is a Cleveland detective, McFadden, on a downtown beat, which he had been patrolling for many years, observed two strangers who are identified as the petitioner and another man named Chilton on a street corner. He saw them proceed alternately back and forth along an identical route, pausing to stare in the same store window, which they did for a total of about 24 times. So here's your policeman. He's standing there, and he's watching this behavior. Okay? This guy's a policeman for, 30 years? Doesn't say 30 years, but I think a little later on we're going to find that Officer McFadden had been in the police force for many years. So he's a professional, and he's watching this, and he can just sense that this is a heist. There's a crime about to be committed here. Doesn't have any probable cause yet. You know, there's no crime. These guys just walking up and down. Each completion of the route was followed by a conference between the two on a corner, at one of which they were joined by a third man, whose name was Katz, K-A-T-Z. And in case I've omitted this, you should look this up now. It's called the Terry versus Ohio case. So take a look through your Supreme Court. It'll be Supreme Court decisions 1, 2, 3, 4, 5. Pull this out, and I'm on page 1 of Terry versus Ohio. Now follow along, because as you follow along, I'm going to make comment, and I'm going to show you how the Supreme Court works, how their brain functions, so to speak. Because you may be pacing up and down sometime, and a policeman come up and grab you and want to search. And if you do, you're going to need to know how to conduct yourself. The policeman, at that time, you see, you may want to see if he wants to go a little bit further than a search, if maybe he wants to go ahead and violate your right. If you're a policeman, you need to know and understand Terry so that you don't go too far, so that you don't let somebody bait you in to a confrontation where you could later be sued, because there are going to be a lot of citizens and they're going to be bringing a lot of lawsuits against a lot of policemen, because I'm teaching people coast to coast and border to border. And we know how to do it, and we're going to do it to you. You policemen and you public officials out there are going to stop shooting niggers off the front porch, and that's where that's at. So here we are back here with Officer McFadden, and now there's 3 men in front of a store, and this man Katz, he left swiftly, and suspecting the 2 men of casing a job for a stick-up, the officer followed them and saw them rejoin the 3rd man a couple of blocks away in front of a store. The officer approached the 3 men, identified himself as a policeman, and asked them their names. When we get to Brown versus Texas, you know, if you're one of these 3 men, what are you going to do? Who in the hell wants to know? That's my response. I wouldn't tell him who I was. The men mumbled something, whereupon McFadden spun the petitioner around and patted down his outside clothing and found in his overcoat pocket, but was unable to remove a pistol. The officer ordered the 3 into the store. He removed the petitioner's overcoat, took out a revolver, and ordered the 3 men to face the wall with their hands raised. He patted down the outer clothing of Chilton and Katz, and he seized a revolver from Chilton's outside overcoat pocket. He did not put his hands under the outer garments of Katz, since he discovered nothing in his pat-down which might have been a weapon, or under the petitioner's or Chilton's outer garment until he felt the gun. So the policeman is patting these 3 fellows down, looking for a gun. The 3 were taken to the police station. Now see, after he's found the guns, but before the robbery, he takes them to the police station. Petitioner and Chilton were charged with carrying concealed weapons. Now, right away we begin to say, uh-oh, damn dirty cops, charge these guys with constitutional rights. Why, they've got a right to carry a gun, and there goes our Second Amendment right. Let's not be hasty. Let's follow through now, and let's find out, like a good judge would do. Let's put our neutral hat on. Let's not judge the policeman, and let's not judge the defendants. Let's get all the facts, and then let's weigh the facts against the law, and then let's measure the law against the Constitution and the Bill of Rights, and determine whether or not the law, in this case, with these people, in this circumstance, applies to these 3 people. And that's what the court's duty is, and that's all that it is, and that's all they ever do. Sometimes they just say, don't pass go, go straight to jail, do not collect $200. And sometimes they say, advance to boardwalk. And that's just the way the courts are. All right? So the defense moved to suppress the weapons, though the trial court rejected the prosecution theory that the guns had been seized during a search incident to a lawful arrest. They weren't under arrest. He didn't walk up to them and say, hey, you're under arrest here, and then search and find the guns. Because what we're trying to determine here is, how does this unreasonable versus reasonable search and seizure apply? Can policemen just come up and pat you down and find a concealed weapon and then charge you with the crime? What probable cause did he have to believe that these guys had a gun? See, he was suspicious that they were going to rob a store, but can you just arrest people, take them to jail, because you suspect that they might be robbing a store, and then find some other crime by accident? Or charge them with obstructing and delaying a policeman, or some other phony, fictitious charge? The court denied the motion. Now, the court, that's the trial court. Trial courts are prone to error. All right? Remember, now the trial court denied the motion to suppress and admitted the weapons into evidence on the ground that the officer had cause to believe that Petitioner and Chilton were acting suspiciously. Okay? Well, I don't know. Is acting suspiciously a crime? Do you throw people in jail because they're acting suspiciously? What is suspiciously? Who determines what suspicious is? A policeman who's malicious and has evil and wicked intent could just come up to you and arrest you and take you to jail. Well, he was acting suspiciously. Do we want police to have that kind of power? They just walk up, well, I don't like you, Gordon, I've had it with you. You're acting suspiciously, you're under arrest. Is acting suspiciously a crime? I don't even know what acting suspiciously is. Maybe I've seen it on Columbo or Kojak a couple of times. I don't know. Anyway, they were acting suspiciously, and that their interrogation was warranted. I don't know if interrogation is warranted or not. Are their answers compulsory? Do they have to answer? If the policeman sat there and asked them 50 questions, do they have to answer the 50 questions? I don't. So if the policeman wants to sit there and ask questions, okay. Are you going to answer my questions? No, not until I have counsel present. Are you going to cooperate with me? Absolutely. I'm certainly going to cooperate with you in every way, officer. Well, then answer my questions, or I'm going to arrest you for obstructing and delaying. Hold it. This is a Fifth Amendment right pursuant to the Miranda Doctrine, and I'm going to exercise my Fifth Amendment right to remain silent until I have counsel present. Well, what if counsel's present? Do I have to answer his questions? If I had counsel present and my counsel said answer his questions, I'd fire the dummy. You don't answer questions for your adversaries. You don't have to prove you're not guilty or innocent. Those are called exculpatory statements. I don't make exculpatory statements and I don't make inculpatory statements. Any statement you make can and will be used against you in a court of law. Let's go on. And that the officer, for his own protection, had the right to pat down their outer clothing, having reasonable cause to believe that they might be armed. Well, it appears that they might have had that. The court distinguished between an investigatory stop and an arrest, and between a frisk of the outer clothing for weapons and a full-blown search for evidence of crime. Looks like they found evidence of crime, though, in the outer clothing. Petitioner and Chilton were found guilty, and intermediate appellate court affirmed, and the state Supreme Court dismissed the appeal on the ground that no substantial constitutional question was involved. And when the Supreme Court got the case, they marked HELD. So the opinion of the lower court was held. No constitutional question was involved. Now, isn't that interesting? Well, does that mean the policeman can come up to you, a citizen, and search you, find a concealed weapon, take you to court, try you on a concealed weapons charge, and there's no constitutional question involved? Now, I want to show you an extremely important thing here called staying on point. We don't know at this juncture of our reading what the status of these three persons are, do we? As we read along, we're going to find out that all three of these fellows are convicted felons who are on parole or probation. Now, when you're on parole or probation, can you carry concealed weapons? Well, the answer in this state's no. Not unless you have a gun permit from the sheriff. See, a sovereign citizen who has all of his political, economic, and judicial rights and is not bound to service for a term of years, he has the right to carry the concealed weapon. But these fellows here don't have a right to carry the concealed weapon because we're going to find out these fellows are all convicted. They're on parole. And so when the court tried them, you see, for concealed weapons, they were committing a crime and they didn't have any Fourth Amendment rights or protections. Because in their parole it said, you will not carry guns, you will not have any bullets, you will not do this, you will do that, you will report here, you will report there, and any violation of the terms and conditions of this parole will then revoke your parole and put you back in jail. Here's the important thing to remember in the Terry case. These people were on parole, so therefore they had no Fourth Amendment right. If Officer McFadden had come up to me and done that and found that gun, we would have had a different question. The question would have been, can a policeman come up and search a person and then use the evidence against him, and when you go through the search and seizure law report, you're going to find, no, can't do that at all. It's been done before. In this case, the officer lucked out, say. The officer, had he done that to me, would have been committing a felony under Title 18, Section 241. He'd have been violating my civil and constitutional rights because he didn't have probable cause. But he lucked out in this case, and so this is called lucking out. When the policeman stops you, and he searches and he finds the marijuana, and we're going to get into the Carroll case here, and I'm going to show you how the Carroll case comes into play. And they find the evidence through what's called exogenic search. Yeah, they can use that against you, and you can claim, well, I had probable cause and reasonable suspicion, and I went ahead and I acted. Now, when the policeman comes up and grabs you and pats you down, don't panic or make any sudden moves, because when you're demanding rights, the police are going to be psyched out for several months. As soon as a few citizens in any local area begin to demand their rights, the police begin to think, well, they're communists, fascists, Nazis, they're, I don't know, they'll hang labels on you you can't even dream up. Because it's strange and it's unusual. Americans are not the type of people who demand their rights. Americans are timid sheep who just, and if you don't think they're timid sheep, you know, we try this in class constantly. Let me lay this little trip on you. A new student comes into class, and one of the first things I do, oh, excuse me, sir, or excuse me, ma'am, there's some information I need here from my records. What was your name again? And I take their name, and they'll give it, and I'll go, well, now, what's your social security number? And they'll give me the social security number, and I write that down. And, are you married? Yes. And how many children? Okay. Are you employed? Yes. And where are you employed? And I'll put that down. How much money do you make there? $6 an hour. How long have you been there? 5 years. What was your work history before that? And I'll go on and on and on and on and on. And about this time, the students are just sitting back here rolling on the floor. You know, I've had them, just tears rolling down their cheeks, you know. And this new student's kind of sitting there wondering, what's the big joke? Okay. Now we go back to question one. Let me ask you a question. Did you come in here of your own free will and choice to this school? Yeah. Mm-hmm. Did you pay for this education? Yeah. Okay. Did I ask you for your social security number? Yeah. Were you expecting me to send you a social security check? Well, no. Why did you tell me what your social security number was? Would you ask for it? Oh, okay. Didn't you tell me how much money you earned? Whether you were married? How many children you had? Yeah. What relevance does that have with this court? I don't know. I guess you needed it. Why? Why did I need it? Why do I need to know your date of birth? What relevance does it have? Ask yourself. You're sitting there in front of your TV set. What relevance does it have whether I know your name or not? I'm not going to send you a birthday cake if you told me when your birthday was. So why do I need to know your date of birth? You see, this thing called private information is just that. It's private information, and it's protected under the Fourth Amendment. Private information you can give out if you want to. But I could use it against you. How could I use it against you? Well, what if you're breaking some Social Security law? What if you've got your children at home and you're not sending them to school? What if you're divorced and married to another woman and your divorce isn't final, and I ask you if you were married and you said yes, and maybe you're guilty of bigamy? I mean, anything you say could be used against you. It's none of my business, and so why don't you train yourself to keep your mouth shut, don't say anything, and shut up? You've been to the government schools, and the government schools have taught us all that if you don't answer all of the questions, that you have something to hide. And I want to ask you, ladies and gentlemen, do you think that I look like the kind of man who has something to hide? Let me tell you, that's right, I do. I've got a lot of things to hide. My privacy is my business, and it's none of yours. And if I want to tell you something, I will. And if you ask me, I'll ask you, who in the hell wants to know? And if you think I'm rude and obnoxious, you're right. I am. And I'll tell you something else. Anybody else that asks me what my Social Security number is a rude and obnoxious person. And anybody who is rude and obnoxious to me and asks me a rude and obnoxious question is entitled to get a rude and an obnoxious answer. It's none of my damn business who you are, what your numbers are, what your business is, whether you're married, how many kids you got, or anything else about you. When I become your friend and when I have earned the privilege, the capacity to call myself your friend, you may want to share that information with me of your own free will and choice and volition. Not because I'm rude and obnoxious and nasty, and because if you don't tell me, you've got something to hide. Always remember, it's none of my damn business what you do. And it's nobody else's business what I do. It's none of your business what I do in my bedroom. It's none of your business whether my basement's full of hand grenades or honey. Uzi submachine guns or blank checks or whatever's in there is nobody's business but mine. So long as I'm not hitting you in the nose, as long as I'm not violating anybody else's rights, as long as I'm not breaking any law, nobody's business what I'm doing. So one of the first things you've got to learn is to keep your mouth shut. And you always ask the question. Whenever somebody asks you a question, you have to ask yourself, you know, this is an awful rude person who asks questions of me. Policemen are I don't know if they're naturally this way or trained this way. Policemen are rude and obnoxious people. And stop. They ask you questions that are none of their business, and they just kind of talk to you. They talk down to you as if they've got some specific right to know something. You know, I've been in the business world for a long time, and I never had one of my servants ever come in and put his feet up on my desk and ask me whether or not payday was on Friday, or ask me whether or not he was taking the truck out, or ask me whether or not this or that or something else. I've had a few employees come into my office. Sometimes they sit down, sometimes they don't. It just depends on how I feel. Now, a public servant is a public servant, and you need to establish that going in. And listen, my employees don't ask me personal questions. Sometimes a friend may, but if he's a friend, he doesn't ask questions that violate Fourth and Fifth Amendment rights. I don't have any friends that violate my right to privacy. And anybody who violates my right to privacy isn't a friend. When I'm dealing with my friends, I don't ask my friends about their personal lives. It's none of my business. If they want to confide it in me, then I consider that a friendly gesture. I don't ask my friends if they're married. I don't ask my friends about their personal life. Let's go on and pick out another case. I'm going to pull over here to a case called Almeida Sanchez versus U.S. So go through book 1, 2, 3, 4, 5. And let's pull out Almeida Sanchez versus U.S. And do I want to talk about that lesson right now? No, I don't. The case that I want to talk about right now, forget that one. Let's talk about Carroll versus U.S. Now, you'll notice I'm using a black binder. And the reason for that is that I went up here and I just searched and searched. And went through the books, and I've dug these out, and I paid 15 cents a page for these, and we've put these into book form. A binder like this with all these cases, I may have $100 invested in this. And these books give you the key cases so that you don't have to do this. But listen, don't let that stop you. When you're looking around through cases, don't spare any money or any time, effort, and energy. When you see cases that are important, get yourself a black binder like this one and document these cases so that you can have some first-hand information. I'm looking for Carroll versus U.S. here on Lesson 3. Let's see if I can find it. Here we go. Carroll versus U.S. was decided in 1924. It's called Carroll et al. Versus United States. Decided, well, let's see. twice. March 2nd, 1925, right in the middle of Prohibition. Now let me give you a little background to this particular case, and this is the famous Exogenic Search case. Do you have to have the physical warrant, that is, this document, right out there on the arrest site, in hand, signed by a judge, supported by affidavit, right then and there, in order to make a search? That's what this case was all about. Now the background to this one is, it's interesting and unique. The Carroll boys were well known to be bootleggers. And the way the system worked was, Canada was not affected by Prohibition. And so up in Michigan, they were just across the border, or just across a lake or a bridge, from buying booze over in Windsor, Ontario, and then bringing it into Michigan. And then they'd take it down to Chicago and spread it all over the United States. So it came in through Canada. How much booze come across that border, God knows, I don't. But let me tell you, during Prohibition, I don't believe anybody went dry. Because I know where I came from. My grandfather ran a still between 1925 and 33 or 34 when they put an end on Prohibition. And during those early Depression years, you know, business was so poor that the thing that finally put my grandfather out of business, he was in the cattle business, and buried him, was the end of Prohibition, because they couldn't make any money in the cattle business. They were just making money turning their grain into booze. People had money for booze. They didn't have money for much of anything else. And the stories that I've heard through that period was, here was the moral majority of their time enforcing their morals through law, and in this case a constitutional amendment, which, believe me now, is the supreme law of the land. Booze is against the law in this period of time upon all the citizens, and so the citizens say, we don't give a damn, we're going to go out and drink anyway. So people will basically do what they want to do. You can legislate against pot, but people are going to smoke pot. I mean, if pot were legal in the morning, the price would just like that. Couldn't sell the stuff anymore. And that's the way booze was. And the Carroll boys are going into Canada, and they're bringing booze down, and they operate between Windsor and, I think it was Grand Rapids, Michigan. The police know this, but the police can never get the goods on them. They just, you know, they don't have the warrant, and when the Carroll boys are running empty, they're stopping them, and when the Carroll boys are running full, they don't, and they don't have a warrant, and they've been in court, and they keep throwing the case out because they can't get a search warrant to search the car. So they decided to try some new ground. Now, this is a case where you've got some new ground. Actually, there's nothing new here. It's just that the application is changed. The application of this Fourth Amendment's changed. When you're operating on the roads, remember the police powers attach out there on the roads, and where there's police powers and privilege, there aren't rights. So you have to keep that in mind. Now, the subject of whether or not the Carroll boys had driver's licenses or not, I don't know. If they had a driver's license, they didn't need a Fourth Amendment warrant, unless there was some civil right that protected it. But basically, the way the case came down was, the officers ran out, they got a tip. Say, somebody called them on the phone and said, hey, the Carroll boys just left Windsor, and they got 20, 30 boxes of booze in their 1924 Studebaker sedan or whatever it is. Police run out, stop them. Search, sure enough, there it is. Now, the Carroll boys go into court and they argue, no search warrant, therefore the exclusionary rule comes into play. We want the evidence excluded. No hooch, no conviction. You haven't got any case. Went clear to the U.S. Supreme Court, and the Supreme Court said, certainly you can make an exogenic search. You see, you don't have to have the physical warrant in your hand if you have probable cause, and you can then go get this warrant, and you can go get the affidavit. You have to have all of the indicia to a Fourth Amendment warrant. The person and place to be seized, the property to be seized, where, probable cause, reasonable suspicion, affidavit, testimony. You've got to have it all. But because the automobile could travel clear through the county and be out of the jurisdiction before the guy could go get the warrant, the policeman could go get the warrant, the court said, we've got to change the application of the rule. We're not going to change the rule, just the application of it. There's one other thing that the Carroll boys can do. Hold it, stop right here. We have probable cause to believe that you're carrying contraband. We're going to go get a Fourth Amendment warrant. You don't move. Now, they can hold you for a reasonable length of time. I've had this happen to me at some truck scales. One time I recall they thought my truck was loaded, and I said, well, get a warrant. Now, they didn't need to go get a warrant. They could have used the Carroll Doctrine of the Exogenic Search and just searched my truck. But boy, if that truck wasn't loaded, and if what they thought was in it wasn't there, boy, have they got a can of worms. And so I just push them right to the wall. You know my philosophy? Just like the communists. You take the knife and you push, and if you feel mush, you just keep poking. If you feel steel, back up. If it's good for communists, it's good for citizens. It's the way I figure. So the police down at the scale, they're sitting there saying, we know Gordon's got load in that truck. This is what the policeman's telling me. I know you got that truck loaded, Gordon. If you know that truck's loaded, then you don't need a search warrant. Why don't you just use the Carroll Doctrine and break into it? See what you do? Just intimidate him. And it's like a poker hand, you know, at this point. I'm sitting here, there's my bet on the table, big mouth. If you want to see my cards, put your money where your mouth is. See the way that goes? In other words, intimidation works both ways, and the police are trained to be intimidators. That's why they're like ex-Marines. Boy, those Marines are tough. You know, Marines are mean. They're trained killers. And they like to have those Marines on the police force. So do I. I like police out there that are real nasty, tough guys. I just want them to know and understand the law so that they don't abuse me. I want them out there protecting me against these vicious, heinous criminals. I don't want them out there writing traffic tickets and throwing women in, like they do in Cook County, what is it, Chicago? Is that Cook County? Arresting women and strip searching them and abusing people like that. It's insane. So the Carroll Doctrine, then, is a doctrine that doesn't subvert or change the Fourth Amendment. Because if you're willing to wait the 3 hours, well, he'll go get a search warrant. And that's what I always make him do. Don't search, go get the warrant, come back, then make the search. Then always challenge that search. In other words, whenever they come to you and say, well, here's the warrant, dummy. Oops, you don't need to read that. This is a legal document. Hold it, you. Don't you move. I want to see that warrant. I want to see who my accusers are. Who's signed this affidavit? That's what I want, because when that signed warrant comes back, it'll have some errors in it. And then you stand in front of the door or stand in front of the truck and tell them, don't make this search, this warrant fails. And then make them push you out of the way. Now, don't get into such a position that they're going to have to beat you up or knock you down. I mean, I'm not talking about a confrontation. You're not going to look. Because not only are they going to look, they'll kill you if they need to. What you need to do is to put up, this is the Fifth Amendment, that belligerent claimant in person. See, you can't be passive about it. You've got to put up an active resistance. I demand my rights. Don't search. And then let them push you out of the way and then go ahead and make the search. Because now they're going to find the marijuana and the contraband, but now you can get it excluded from evidence in an exclusionary hearing. It's called the exclusionary hearing. It's a hearing to exclude evidence. Now, if you want to study a little about this thing of procedure, look up the word procedure or evidence in your local law library. Go in and ask the law librarian. You know, you need to study and you need to be knowledgeable about some phases and procedures. And you go into the law librarian, and this is a philosophy that I've used for years. I'm dumb as a post. Okay? I don't know nothing. So I walk in the law library, and I learned this in the 3rd grade. You don't really have to know anything. You just have to know how to go find it when you need it. And in our law library, we have a nice lady up here who's a law librarian. Her name is Laura. And I go into Laura, and I say, Laura, I'll tell you what, I got a case coming up, and I need some evidence. I need some information on evidence, and you know how to lay foundation to get evidence in, and I need to study that. Have you got anything on that? Follow me, Mr. Gordon. And she'll take me over and show me 50 books on evidence. Just pick any one out. I mean, you know, lawyer's lawyer, and authors are authors, and you pull one out and you read about evidence. How do you lay foundation to put evidence in? What is competent evidence? How can you get evidence excluded? Exclusionary hearings on evidence, you see, and you're going to read about that. And there's 50 authors and there's 50 books, and I'm not here to recommend books. I'm just saying you need to go in and read something about evidence. That's all they're going to tell you in law school. Today we're going to study evidence. I want you to read pages 87 to 94, and we're going to have a test on Friday. That's all I tell you. I went to the government schools. I know how that phony baloney works. So do you. Now there's evidence. You want to know a little something about search and seizure? Any topic you want to know about is in your law library. And the law librarian knows how to dig it out. Evidence is going to be one of those topics. And evidentiary hearings are going to be right in the middle of evidence, because there's going to be a lot of Supreme Court cases and rulings, and this is the way it's done and the right verbiage. How do you speak when you go in the courtroom? Just listen to Perry Mason. He's got it just about right. Those are about the right terms and the right phrases and the right pauses. Go into some trials and listen to prosecutor and defense. Watch the proceedings. I'm just like the Japanese. I just copy what they do. I can get a motion for discovery from an adverse attorney. If you want to know how to really turn your adversary into a raving lunatic, here's how you do it. The other day I got a civil suit going, and I've sued a policeman, and I want some money out of him, and I don't know how much I sued him for, a lot of money. And there's an insurance company that's trying to prevent me from collecting on that insurance policy. See, the officer, he's not responsible for his actions. He goes out here and beats people up and throws them in jail. Remember, he's a servant, he's a slave. The master of the insurance company is responsible for his actions, and they're defending the action. And they hired a law firm up on the 16th floor of the tallest building in Boise, Idaho, which is called Idaho First Plaza. Okay? That law firm probably costs about $600 an hour. Now, that's a rumor. You know, a dumb lawyer in Boise, Idaho gets $60 an hour. The smart one gets about $150. Rumor has it they get $600. So let's just say that they're just good lawyers. They're on the 16th floor. They got the whole thing. I don't know what their overhead is, but I'll tell you it's plenty. So I know that it's probably one of the better law firms in town. I'm going to go so far as to say it's probably above average. And I'll bet you they charge a little above average, right? And so they have an attorney there who's really good, because I went in, I talked to him for an hour and 10 minutes, and he could stay on point. He stayed on point for an hour and 10 minutes. That's right. Lawyers who are good can stay on point on the subject matter. He wrote, pursuant to the rules of civil procedure, a motion for interrogatories under Rule 33. The way I got that figured is, anybody who's been to law school and who works for a law firm as prestigious as that law firm must know something. So I wanted to write some interrogatories of him. And I haven't been to law school, and I'm dumb as a post. So I just took his paper, and I just copied it word for word, and the only thing I changed is the names, dates, times, and places. That's all I changed. I used his language, his terminology, and his prose, and then I just turned it right around and gave it to him and said, now you give me this information. See how that works? You suppose he's sitting up there mad? I hope he is. Remember the Edison principle? You see, I don't have to know anything. I just have to know where to go get it. Where do you go get it? You know, when I filed that lawsuit, there came a time in my life when I had to file the very first lawsuit. Right? How do you do that? Well, they sued me once. So you just take the suit that somebody sued you with, and it'll probably have all of the indicia in it that you need. And you just copy it and just change the names, dates, times, and places. You think that's too simplistic? I've been doing this for 5 years, never lost a case yet. Never been to law school. Never lost a case. The way I figure, them fellas got to be smarter than I am. And therefore, if they're smarter than I am, if I do what they do, I'll be just as smart as they are. No smarter, but at least as smart as he is, because he's the one that asked me for the interrogatories, and if he's right, I have to be right. And if there's a mistake in his paper, the mistake in his paper will be in my paper, but if he's dumb enough to make that mistake, then it's pretty obvious to me that he's not smart enough to call that mistake on me, because he made it, didn't he? Now, if he recognizes his mistake and he calls it on me, then I know what the mistake is and I can call it on him, and therefore looks like to me then that I can call that mistake, make my objection timely. Now, I said that in a rather simplistic and sarcastic manner to illustrate a point. Remember, reason, logic, and common sense. It'll work for you all the time. Now, you may be an auto worker, or you may be a factory worker, and maybe there was a man came in here the other day. I mean, his vocabulary and his command of words, phrases in the English language, his double negatives and split infinitives, and his total overall grasp of grammar was so atrocious that, it's embarrassing listening to the poor fellow, because he can't express himself or communicate at all. But I'll tell you, the fellow's got good, basic logic, reason, and common sense. He can't type. He's a mechanic. Why do you need to type? Can a layman be held to the same standards of excellence as an attorney? The answer is no, you can't. Go to words, those quotations. What's that book now? Legal Quotations. And just take a look under, I forgot which case it was, but there's one in there like counsel. I think it's probably under counsel. There's about 50 cases quoted under counsel. Argersinger versus Hamlin is in there. Can't throw a man in jail unless he's got counsel. But there's another one in there that says the Supreme Court's already ruled you cannot hold a layman to the same standards as an attorney when he's appearing pro se. When I make a mistake, I can say, hold it, the Supreme Court says you can't do that. But God help that lawyer if he makes a mistake and I find it. See, that's why I'm not a lawyer. When a lawyer is working against me, it's 60% in Gordon's favor and 40% in his favor, because if he makes a mistake, I'll call the technical error and move for dismissal. I'll call for the technical error and move for summary judgment. And sometimes I'll get it. When he does that, I scream, hold it, pro se, can't hold me to those standards. Nope, can't do that. And that's the way you need to learn to work. Now, one fellow told me one time, he's a pretty close business associate, and he said, Gordon, if you can't go into the courtroom and get the jury to find you not guilty, you're cheating. You're not doing this right. Let me ask you a question. You're a boxer. You get into the ring with a guy, and you're boxing around there for a while, and pretty soon the referee stops the fight and gives you the TKO, and he says, I'm going to stop the fight. What do? Say, wait a minute, I'm not going to accept this TKO because I didn't knock him out. I didn't win this the way I wanted to win it. I wanted to knock him out in the 8th round, and I didn't knock him out till the 10th, so I'm going to give him the victory. Is that the way you do that? Let me tell you, friend, there's only winners and losers on the courtroom floor. And if you don't win, then you lost. And that's where that's at. And that's the name of that tune, as this famous detective on TV used to say, and that's the name of that tune. I play the game to win, and I play the game to win every time. And the old saying, that winning isn't everything? That's right, it's the only thing. Because when you're operating in the courtroom demanding rights, what's going to happen is when you lose, the judge is going to throw you in jail. And boy, these traffic court judges now, They are prosecutors. They wear two hats. When you go into those courtrooms, you got the prosecuting judge and the prosecuting attorney. And then if you've got a public defender, then you've got a prosecuting public defender. He's all in on the scam, too. You want to find out how competent your public defender is, ask him how many cases he's won in his career. All right, so now back to the Carroll case. I'm not going to go through here and read the Carroll case to you. I want you to read that Carroll case for yourself. It's 267 U.S. 132 is the identification, but you have it in your packet, and it'll be in one of those books, 1, 2, 3, 4, 5 Supreme Court decisions. And remember, this Carroll case now is a landmark case. You must read it. You must understand it. It's in simple layman's language. I mean, anybody who's been to the 6th or 8th grade can read this. When you get into words that you don't understand, stop, hold it. You've got to understand the word, friend. If you don't understand the definition of specific performance or inland bills of exchange or income and compensation, etc., or of person, you've got to stop, get Black's Law Dictionary. Now, you can probably all afford to go out and get Black's. This is Black's Law Dictionary right here. And get the basic definitions and understanding of words down and in your mind. There's probably 100, I'd say no more than 200 legalese words that you need to know and understand in order to go in the courtroom. And if you want to use a little razzle-dazzle, you should practice with other fellow patriots. So that when you're practicing with your fellow patriot, you're using the words, and I use them here all the time. Listen, when I go into court, and tomorrow I'm going into court again, I practice on my friends, and we talk and use these terms and these words and these phrases. And then when I don't have the phrase down just right, let me rephrase that, Bob, and I'll read it to him again, or I'll say it to him again. He does that to me. And let me tell you, that really sharpens you up. And you should try to get 4 or 5 people to help you so that you can study these words. Remember, this is a war of words. This is a game of words. And I like to refer to the courtroom as a game because I'm a competitive type of person, and it's fun to me, and I don't work anymore. I used to work and work hard. I don't like to work anymore. What I like to do is play. And I play at this, and I'm good at it, and I have a lot of fun at it. And you should have a lot of fun at it, and it's profitable because, you see, after you've begun to win some cases, then you're going to sue your government and make money. And that is until they stop violating your rights, and when they stop violating your rights and start obeying the law, then there won't be any more arrests, and then they won't be taking you to jail, and then there won't be anything to argue and fight over, and so therefore you can go find some other game to go play. And until they do that, then I'm just having fun playing this game. So there's the famous Carroll case. Now, the next one I want to bring up is going to be Delaware versus Prowess. Delaware versus Prowess is a typical traffic case. There's nothing really unique or spectacular about it. It's a search and seizure type case. Comes under the exclusionary rule. To show you that the Supreme Court listens to some of the most trite issues. You don't have to be IBM or Hewlett-Packard to get your case into the Supreme Court. In fact, the Supreme Court listens to dozens, if not hundreds, of convicts in prison. I mean, they're taking cases right out of Joliet, Illinois, and listening to convicted criminals in their complaints for deprivation of rights. So traffic cases and all kinds of little rinky-dink cases come to the Supreme Court because the court is trying to decide rights issues. It doesn't make any difference if it's a multi-million-dollar case or it's a case, as in Brown versus Texas, the total amount of fines only amounted to $60, and that's why the Supreme Court took that. Brown versus Texas case is because that the Texas Supreme Court wouldn't listen to it. Right out of the district court, right straight to Washington, and won his point. Well, this fellow Prowess is an ordinary, everyday garden variety driver, and he's driving down the road, and the police officer stopped him in a routine check, just checking driver's licenses. That's all. No probable cause for any crimes or anything like that. But when he made the stop, he found some marijuana. And the marijuana was then used against Prowess, and Prowess then argued that, wait a minute, there was no probable cause to make the stop. So let's listen to a couple of terms here and write these down, and you're going to have to learn these because there's not more than a few terms, but when you hear a term used, like the neutral indicia rule or the plain view rule, I want to explain those right now because those are crucial. You see, when the policeman has probable cause to stop you, and then because of plain view, he looks in the car and there's marijuana sitting on the seat. He can't ignore a violation of the law when it's right in plain view. You know, you're driving down the road and you pull over and the policeman comes up and here you are with a can of beer in your hand. I mean, it's pretty obvious, isn't it? Does he ignore that? No. He had a right to make the stop. And if he had a right to make the stop, principle being if the policeman had reason and law to be where he was at the time he saw the act or action, then he can use that against you. And that's been around for a long time, so that's not 1 Gordon 14:4, and that isn't some kind of subversive doctrine. That's the way it's always been. Okay, that's called the plain view rule. Now, there's a rule called the neutral indicia rule. When I was down in Texas driving a truck, I noticed that down there they look for illegal aliens down close to the Mexican border, you know, pretty hot and heavy. And they'll put a roadblock up across the freeway, and they'll stop every single truck and car and vehicle. And then they'll either search it or not. Now, that's called neutral indicia. They can stop every vehicle for a stated purpose. That's called a roadblock. Let's say that they're looking for a bank robber. And you're driving down the road, and oops, there's a roadblock. You can stop and turn around and go back. You don't have to go through the roadblock. You're going out to the airport, and you're going to get on an airplane. Neutral indicia. They search every passenger getting on that airplane. You've got a gun. If you walk through there, you're in violation of the law if you don't declare the gun or the catch knife. But you don't have to go through there. You can stop and say, wait a minute, I'm not going to be submitted to this search. I'm going to turn around and go back. All right, now I don't know what they're going to do. They can stop you and say, are you a bank robber? I don't want to be submitted to any search. I demand a warrant. Now, they're looking for a bank robber, so they can't search your vehicle and they can't take away from you or use against you this contraband. Now, bear this in mind. They're not going to give you back your contraband. My common sense tells me if I wanted to smuggle marijuana, I don't want to use a $30,000 Porsche to do that. I want to go down to Hertz and rent a car. If I get caught, I want the government to impound and take Hertz's car away from them. I don't want them to take mine. I'll go get a $100 Pontiac and go do the job. So keep that in mind, because now there's another term that's used, and it's called seizure of the fruits of crime. So if you get caught and you've got an Uzi submachine gun in your trunk, and if for whatever reason the trunk is opened, if you refuse to open the trunk and you demand a warrant, and then they go ahead and open it anyway, they're going to take the gun all right, but now you can successfully get that gun suppressed. That evidence can be suppressed because they don't have any probable cause to believe that you're in the Uzi submachine gun business. So I'm going to run through this Delaware versus Prowess because this is a pretty significant case. We're talking about some real high-powered cases that were quoted here. And Colonnade Catering and U.S. versus Biswell are quoted in here. And as you're reading these cases, there's the thing that you're going to note, that the Supreme Court doesn't take a case and say, well, we all took a vote. We went in the back room, we took a vote and decided that Prowess was guilty or not guilty, or we're going to turn him loose or we're not. They don't do that. What they do is they go through and they say, we have determined over and over in United States versus Biswell, we've determined in Carroll versus U.S., these other landmark cases. They always go back to the law and say, we've determined in the past thus and such, and therefore we're applying it to this case. Or the doctrine of thus and such or so-and-so applies here. The Supreme Court, doesn't create new law. I had lunch not long ago with a judge, and we discussed this very thing, and I said, Judge, do you know of any new law? And he said, Nope, I don't. It's a good point, Mr. Gordon. I can't think of any new law. Well, when was the last time any new law was adopted? Paused for a long time and said, well, I suppose you could call the exclusionary rule new law. It started about 1876. And I thought about it for a long time, and I said, well, yeah, I guess we couldn't call Carroll or Miranda or Escobedo new law, could we? Yeah, I think that the exclusionary rule doctrine that began with the Boyd case in 1876 is probably the last time we had any new law, or what we would consider new application of law. Well, we could probably say the 14th Amendment was probably new law. That applied the Bill of Rights to the states about 1867. Yeah, that's new law. And every constitutional amendment applies new law, but of course the Supreme Court didn't create that, did they? The legislature did that. And so, you see, what I'm trying to tell you is that the Supreme Court doesn't create law. They just rule upon the applicability of the law. And most law, and this is another rule, another maxim of law that you want to keep in mind, is all laws, rules, regulations, and anything that comes down from any legislative body is assumed to be constitutional. So the premise, the foundation blocks going into the argument, is that statute, ordinance, rule, or regulation is constitutional. It's up to you. That is called now the burden of going forward is on you to determine, to show, to prove that that law doesn't apply to you. And now don't confuse that with proving your innocence. In equity, you prove you're innocent. At law, the government proves you're guilty. But the burden of going forward, that term, used in law, and you're going to hear that over and over again in the courtroom, the burden of going forward is upon the prosecutor. The burden of going forward is now upon you. We call that here in school the ball bouncing back and forth across the net, just like a tennis game, you know. The judge just sits there and watches the ball go back and forth with his neutral hat on, and when the ball hits the net, he just rules the point in this side or that side over there, and whoever gets the most points wins the game, or whoever's point of law. And a lot of times, you know, people say, well, that judge ruled against me. Well, why did you let him rule against you? You see, a judge is going to rule against you, like Delaware versus Prowess. Now, the judge didn't rule against this guy, Prowess. He ruled against the government. The judge rules based upon the rules of the game. He watches the ball come over, and you're there to catch this pass. You catch the pass, you run into the end zone. What did you want him to do? Rule that the pass is incomplete? You catch the pass, you know, and it slips through your arm. Was he supposed to rule complete? How can the judge rule for or against you in violation of the rules? And if he does, that's the time to object and then take it to another referee and say, that referee did err. And that's called reversible error. And that's the way the judicial system works. But, you know, I've been around for a long time, and I've seen some bad lower court decisions, and I've seen prosecutorial judges, you know, that they're really against me, and they're on the side of the prosecutor. And I don't care. What do I care what some fool in the traffic court thinks, or how he rules? Before I get into Delaware versus Prowess, pull out this little book here called Legal Quotations, and turn with me over here to page 61, would you? No, turn to page 60. Turn over here to page 60. Legal Quotations. Pause a moment. I'm going to demonstrate to you a fact. Let me show you this go. Right up at the top, we're talking about counsel. Now, here are some statements, decisions that came out of some famous issues of counsel, or when the court denies you counsel. Now, I've been in the courts of Idaho for 5 years. Never had not yet, have I had a judge say, Mr. Gordon, I'm going to allow you counsel of your choice, You can just have Mickey Mouse or Donald Duck or anybody you want, and I'm going to give you unfettered counsel, and I'm just going to bury this counsel issue. Never happened to me. One judge in this state told one of my students one time, went in and laid out the counsel arguments and briefs and had 100 pages of material. He was ready to argue for 2 hours on the counsel issue, and the judge said, "Excuse me, Mr. Hallstrom, I think that we can probably just dispense with that. I'm going to grant you counsel of your choice." You mean unfettered counsel? Yeah, that's right. Counsel who can speak for me? Certainly. That judge just demolished Bob's whole counsel issue. Bob can never take that issue to the U.S. Supreme Court and claim now that he's been denied counsel. He went ahead to win the case, but I'm just telling you that when the judge obeys the law, there isn't anything to argue about. So listen to some of these quotations. Right here at the top of the page, number 203. Listen to this. "The right to counsel at a criminal trial is deemed so fundamental to the interests of justice that denial thereof automatically vitiates any conviction obtained." Automatically. Murder, rape, robbery, pillage. You deny a man counsel, and that just ends the conviction right there. But the jury came in and found him guilty. I don't care. Doesn't make any difference. You see why you want the judge to throw your counsel out? Last thing in the world I ever wanted a judge to do is say, "Okay, Mr. Gordon, I'm going to let you have counsel." I've never talked to a man yet that could represent me better than I can. And so if the judge said, "Yeah, Gordon, you can have counsel, who'd you want?" And I'd say, I'll just go ahead by myself, Judge. Thank you very much. Best way to shut me up is to just leave me alone, because I'm like a rattlesnake. The more you mess with me, the more certain you are of getting bit. Any constitutionalist, any pro se operating in the courtroom is a rattlesnake. We call them alligators. You mess with an alligator, he can get you. Mess with a rattlesnake, might not get you the first 4 or 5 times. Just keep playing with him, he'll get you. So the conviction obtained is no good. The automatic reversal rule. I'm telling you, friends, it's automatic reversal. It isn't something that maybe, if all the facts are in it, could well be, and we hope that. Automatic reversal. This is true even though there is no showing of any prejudice or unfairness in the proceedings, or even any need for having counsel. They could show that, well, this was such a simple case, he didn't need any counsel. Here's a traffic case in the country that comes down with jail attendant to it that's lawful or legal in this country. I have watched literally hundreds of people walk in the courtroom and plead guilty and have the judge sentence them to jail. Not a one of those is lawful and legal. So what the judge says, he says in our state, now I don't know what they say where you are, the way our judge gets around this is their little spiel. They say, "Mr. Gordon, do you know of any lawful reason why I cannot pass sentence on you today?" "No, Judge. No, none at all." "Okay, in that being the case, I'm going to sentence you to 10 days in jail and a $200 fine." There's your voluntary compliance. He just asked you, do you know of any lawful reason? Boy, ask me that question. You bet. I know of a lot of reasons why I can't be convicted. Argersinger versus Hamlin, no counsel. Powell versus Alabama. Giddens versus Wainwright. I can sit here and preach a sermon to this guy forever. Now if he goes ahead and puts you in jail or passes sentence, you've got a civil rights case. Sue him. Look at the next one. A conviction obtained where the accused was denied counsel is treated as void for all purposes. Burgett versus Texas, 389 U.S. 109, 1967. This Wainwright case is 372 U.S. 335. These are recent cases. This isn't 1832. This is 1968 and 72 and 5. The right to counsel, number 205, exists not only at the trial thereof, but also at every stage of a criminal proceeding where substantial rights of a criminal accused may be affected. Motion hearings, probable cause hearings, preliminary hearings, evidentiary hearings. All of these hearings have substantial rights involved. Have to have counsel. What do they want you to do? Accept a lawyer so that you can be declared incompetent, so that the lawyer acts for you. And what does he act for? The best interests of the union, not the best interests of citizens. An accused must be allowed, number 206, to employ counsel of his own choice, and he must be given reasonable opportunity to do so. You have to be given reasonable opportunity to get your own counsel. Now, that doesn't mean that you can demand Mickey Mouse or Donald Duck and then come into court and say, well, Mickey was busy, he's down at Disney World, and Donald Duck is down at Disneyland, and I just couldn't get him, and therefore I don't have any counsel, and that's baloney and balderdash. That's frivolous. You can understand that there's people that do that kind of silly, foolish nonsense, but let's not discuss that. So there's another one here that's important, because it works both ways. You can't use the law to make fun of or ridicule the law or the proceedings of the court. But you have a right to make these demands, and if the demands are made timely and they're denied, you win. Most of my cases are all wins on technical moves or constitutional issues. Never won a case in a jury trial yet. Not one. I think I've done 6. But 6 juries that came in said guilty, went on to win an appeal. This is number 207 now. Where irreconcilable conflict and hostility have arisen between the indigent and his appointed attorney, it has been held that the court must appoint new counsel in whom the indigent can repose his confidence unless, now listen to this, unless the conflict is shown to be due to the defendant's obstinance, recalcitrance, or unreasonable contumacy. That's a strange word. I need to look that one up myself. Contumacy. Now, you can't be unreasonable and ridiculous, but you don't have to accept appointed counsel just because it's appointed. And there is a number of cases in case law, and when you see our briefs and motions on counsel and motion for counsel of choice, I think you'll recognize that readily. Now, the reason I broke in here and I wanted to mention that is because I told you, don't believe what I tell you. Go to the source and get it from the court. Those 9 fellows in Washington, D.C. are the last word on law. When you can get that judge to deny you counsel, you've won your case. And I don't care what the charge is. The charge isn't relevant. Does that give you a little hope? I talk to people on the telephone that come into my office with some of the most pathetic stories of how they've been framed and railroaded and run through the legal system and the judicial system. And you've seen some movies, and there was a famous movie out here not long ago. The name of it kind of slips my mind, but you probably would remember it if I described it. It was about law and lawyers and how the plea bargaining system works and how a fellow was finally sent to prison for 5 years because his taillights were out and things like that. Listen, friends, those aren't wild, off-the-wall, bizarre stories. Those are true facts. It happens in this state. There are people in our penitentiary, and I've talked to them eyeball to eyeball, framed by their police. That's a fact. Tragic. Can't defend themselves. They're just pawns in a big chess game called the law enforcement growth industry, and they just can't do anything to help themselves. If they could, they wouldn't be out there. Now, I want to get back to Delaware versus Prowess because this is a typical traffic case. Let me read a little bit to you here and give you a little background. Let's get into the case because there's some nifty statements made in here. Now, here's a patrolman. This is a 1979 case, so it's only 2 or 3 years old. A patrolman and a police cruiser stopped an automobile, occupied the respondent, that's the man who appealed to the Supreme Court, and seized marijuana in plain view on the car floor. Well, the dummy should have had it in the trunk. Now, this guy lucked out, and he won the case anyway, because the policeman didn't have any probable cause to stop him. But you know what I tell my students? I'm not telling you should or shouldn't smoke marijuana. I don't know. That's a moral issue. It's not a legal issue. If I want to smoke marijuana, I'll smoke marijuana. If I want to grow it, I'll grow it, and there you go. But it's against the law. It's against the statutes. It's against public policy, as is, I guess, homosexuality is against public policy. I don't know. Abortion. These are some moral questions. There's a lot of people out there that want to smoke dope. And as a matter of common law right, they have a right to do so. I can't tell you what you shall or shall not drink, what you shall or shall not eat, what you shall or shall not grow, and neither can you tell me unless you're engaged in a regulated enterprise. And we're going to get into regulated enterprise. Because that's what this case is about. Is this man engaged in a regulated enterprise that would then cause him to lose his Fourth Amendment rights? Almeida Sanchez. And I'm going to take that one up in the next search and seizure lesson, because Almeida Sanchez is going to blow your mind. When you see that case, you're going to say, I can't believe the Supreme Court does that. Yeah, that's right. The Supreme Court does some very wild and strange things, and they appear wild, strange, and bizarre to the average slave and taxpayer because they don't know and understand what rights are, and so therefore when the court is upholding somebody's rights, they say, gosh, they're turning criminals loose. So here's a guy, he's got marijuana on the floor, and a lot of people say, well, he's breaking the law. We don't care how we catch him. Let me tell you, friend, I can break your front door down and go through your house and find something in there to charge you with some kind of a crime, a building violation or some other crime. I don't care what it is. I'll find something in there, and if I don't, I'll just manufacture it and charge you with it anyway, like obstructing and delaying an officer in the course of his duty. I mean, we can create police-state tyranny if we want to, but I don't think we want to do that, do we, friends? So going on here at the hearing on the respondent's motion to suppress the marijuana, the patrolman testified that prior to stopping the vehicle, he had observed neither traffic or equipment violations nor any suspicious activity, and that he made the stop only in order to check the driver's license and the car's registration. On the assumption, here's a policeman, he's probably been in the Marines. And I don't just pick on the Marines, I'm just saying MP's been in the service. He's just going to check this man's papers. Doesn't that sound like the Gestapo? What if he doesn't have any papers? What if he doesn't have a driver's license or registration?